Good morning. It's 10 a.m. on Tuesday, October the 8th, 2024, and I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin the meeting, I would like to bring to your attention, there is a sign-in sheet on the table by the door. And if anyone would like to make comments about an agenda item, please indicate so by your name as you sign in. Public comments will be accepted near the end of our board meeting. Ms. Bohannon, would you please call the roll?
Don Haynes.
Here.
Chris Lee.
Here.
Wendell Naylor.
Here.
Scotty Porsche. Pam Stevens.
Here.
Tim Wheeler.
Here.
Randy Nash.
Here.
Ms. President, we have a quorum.
Thank you, Ms. Bohannon. This time, I will entertain a motion to review and adopt our agenda. Do I hear a motion?
So moved. Second.
Have a motion by Mr. Wheeler and a second by Mr. Lee. Any other discussion? All in favor, say aye.
Aye.
Any opposed? You have been sent the minutes from our last meeting, our September 10th meeting. I hope everyone has had an opportunity to review those minutes. At this time, I'll entertain a motion to approve those minutes from our September meeting.
Motion to adopt. Second.
Have a motion by Mr. Lee, a second by Mr. Nash. Any other discussion about the minutes? All in favor, say aye.
Aye.
Any opposed? This time, before we go into this, we do have lots of people in the audience this morning, and I want to welcome each and every one of you, and thank you for being here. Mr. Bryant, if you would, we're ready to go over our legal report.
Good morning, board members. And before I start, just wanted to, potentially it may not even come up, but just get out in front of it just in case. I know that based on last month's meeting and this legal report, we are continuing to see kind of a consistent issue with expiration of licenses. One thing I just do want to caution and let you know your options first and foremost is that if the board sees that this is becoming a recurring issue and a recurring problem, that we need to start, being a little more forceful in the sense that people need to get these licenses and expirations taken care of. It is certainly within the board's purview of, I know consistency is massive. We try and be as consistent as utterly possible. But if we're seeing a rising instance of these, we usually do $250 for first offense. If the board feels an increase to $500 is necessary, that's perfectly within your purview. I don't want you all to feel like you're shackled by precedent on that issue if it's becoming a consistent issue. The only thing I would ask is that if the board opts to take that approach, that it be consistent from the beginning of the legal report, because I know that, for them, it's their first one, and for us, it's the 9th one we read on this legal report. And the ordering is essentially arbitrary when I put these reports together. The later ones aren't any more guilty than the earlier ones or less guilty or anything like that. So that'd be my only word of caution is let's just not be harder on the ones just because it's the 10th one we've seen, but it's their first offense. But anyways, first complaint is complaint number 2024-043041. This case was administratively opened following a routine inspection conducted on July 23rd, 2024. During the course of this routine inspection, the inspector observed the following. The manager of respondent establishment had a funeral director's license that had expired on May 31st, 2024, and had not been reinstated at the time of inspection. During the unlicensed period, respondent establishment had an unlicensed individual in position as manager for 17 arrangements. After checking core, the unlicensed individual did not complete their CE until August 5th, 2024, and their license reinstated on August 7th, 2024. The manager of respondent establishment stated that they failed to receive notification that their license was about to expire due to incorrect email and phone number information in the core system. The manager stated they only became aware of the expiration upon being notified by the board, presumably during the inspection. The manager stated they ran into difficulties obtaining the in-person hours for CE, but that at this time their license has been renewed. Based on the above, we'd recommend a $500 civil penalty authorized via consent order and a formal hearing if necessary.
Are there any questions for Mr. Bryant?
I have a question. Just for clarification, in the summary, you said the manager's license expired and then had not been reinstated, and they had also not completed the continuing education. So that why you're referring to them as an unlicensed person as manager?
Correct. So once that license expires, it's expired and you're considered unlicensed until you check all the boxes that you need to check in order for your license to be in a good spot. So essentially, from my understanding, this individual was manager of this funeral establishment. Their license expired. They didn't have all the CE that they needed, and then they got it eventually, but it was after their license had been expired, it looks like, for the entirety of June, July, and about a week into August.
Any other questions?
I make a motion to accept council's recommendation.
Second.
A first by Mr. Wheeler, a second by Mr. Naylor. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carried.
Next complaint is complaint number 2024-043061. This case was administratively opened following a routine inspection conducted on July 23rd, 2024. During the course of this routine inspection, the inspector observed the following. Respondent is the unlicensed manager from the preceding complaint. Again, respondent allowed their funeral director's license to expire on May 31st, 2024, and it was not reinstated until August 7th, 2024. And during this unlicensed period, respondent acted as the manager of a funeral establishment, which conducted 17 arrangements and services during that time. Again, respondent's answer to that was the same, that they had failed to receive the notification due to incorrect contact information, and that they ran into issues obtaining the CE for in-person hours. Based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions for Mr. Bryant?
I have a question. Is it customary or normal procedure to levy a civil penalty against an individual that's less than would be levied against an establishment? Because I noticed it's the same person, but the civil penalty was half.
Yes. So usually what we do, I would say on your typical run-of-the-mill, we usually see it in the increments of a week expiration or maybe 2 weeks, something like that. Usually for a first offense, we go $250 for the establishment, letter of warning for the individual. In this case, we have a longer period of time, again, a little over 2 months. And during that time, we also have varying degrees of how much activity they conducted without someone licensed implemented as manager. Here we have 17, which is on the higher side of what we typically see, and again, that period. So I guess the shorter answer to your question is yes, I would say it's customary for the board to have a smaller amount for the individual. Usually it's in the form of a letter of warning, but since we have a larger period of time and 17 cases, that's the recommendation for the higher 250 rather than letter.
Motion to approve.
Have a motion by Mr. Haynes,
Second.
second by Mr. Lee. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carried.
Next complaint is complaint number 2024-044301. This case was administratively open following a routine inspection conducted on July 29th, 2024. During the course of this routine inspection, the inspector observed the following. The manager of respondent establishment had a funeral director's license expire on June 30th, 2024, and was not reinstated until July 17th, 2024. The inspector found no evidence to suggest that the unlicensed individual committed unlicensed activity during the unlicensed period. However, the unlicensed individual did continue to function as the manager of respondent establishment during the unlicensed period. The managing director and son of the manager of respondent establishment replied on respondent's behalf. The managing director explained that on November 1st, 2023, his mother and the manager's wife passed away unexpectedly. The director stated that since then, he has notified his father He has noticed his father has been more forgetful and disorganized than usual, and stated that his father had been a licensed funeral director for 42 years and had never forgotten to renew his licensure. The director stated that after the first of the year, he began to take over more of the day-to-day function of the running of the respondent establishment. The director stated that during this period, he did not check his father's licensure, as he stated that he, that is the director, always received their renewal notice by mail and email, and assumed his father had also. The director stated his father communicated to him that he believed his licensure expired in October of 2024, but that evidently this was not the case. The director stated that from expiration to August 2nd, 2024, even after renewal, his father did not conduct license activity, including making arrangements with families, conducting funeral services, prep any remains, or even discuss making arrangements with any families. The director stated that all licensed activity was conducted by either him or another licensed director working at their establishment. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
Question, Mr. Bryant, and this may kind of go back to our discussion before we started. The previous case, the guy didn't renew 17 contracts. This one, it's almost like he's still licensed but not doing any activity. How do you feel as far as the being consistent with the same fine for somebody that has done so much more compared to someone that hasn't, if that makes sense?
Yeah, of course. So I think the distinction there comes from is this kind of falls in line with our general pattern of the penalty, the stronger penalty is usually levied against the establishment as opposed to the individual. Again, in our previous example on case one, we did $500 for the establishment, $250 for the individual. Here, the respondent is the funeral establishment, not the director themselves. I am not aware of, and if it's not on this report, it probably isn't. I assume a complaint was not opened against the funeral director themselves. So I do think that's consistent in that nature. One thing that I will say is every case is a little different. Every case is always going to have some facts that weigh in one way or another. Here, what I guess helps respondent is, Mr. Lee, as you mentioned, no unlicensed activity during that period, which is great. Kind of, I would say the hanging violation we have here is that for that, I guess, approximately 2 week, little over 2 week period, even though there was no unlicensed activity, there was an unlicensed individual as manager. And I would say that this is consistent with what the board has typically done. But as I said, too, I don't want the board to feel shackled strictly by precedent. And if the board feels that there are enough factors here that weigh towards a letter of warning or something in that, that's certainly within the board's purview.
Thank you.
I have a general question. Is it that all funeral director license are supposed to be visible or in an office at our facility, they're hanging on a wall? Is that just a courtesy thing we do, or is that a law?
So my understanding of that is it needs to be available during inspection, whether that's hanging up on a wall where it's obvious and can be presented, whether you have it, admittedly, going to tell myself a little bit, like my college diploma, which is stuffed in a closet somewhere, as long as I can go get it and show it, that's what's legally important. So it doesn't have to be specifically hung up or anything like that, but it does need to be available.
Okay, thank you. Any other questions for Mr. Bryant?
I'd like to make a motion to change this to a letter of warning.
Second.
Let me make sure I'm understanding. A letter of warning and no civil penalty.
Correct.
I agree, Mr. Nash. Thank you for that. You got a little
Or is a letter of instruction more, I guess it's kind of a little bit of both, because it's a letter of warning, but also a letter of instruction that they need to get the license, the management changed, probably.
Mr. Nash, which do you prefer in your motion?
A letter of warning.
There's a motion on the floor of changing the recommendation from a civil penalty to a letter of warning by Mr. Nash.
Second.
And a second by Mr. Naylor. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carried.
The next complaint, real quick, just so that the board is aware of this going into it. Complaints 4, 5, 6, and 7 are all somewhat linked. Complaint 4 and 5 are, if my understanding is correct, the same owner, different physical establishments, different license numbers. And then the employee, which is the respondent in 6 and 7, is the same employee who worked at both funeral establishments. So we'll just take them one at a time. But next complaint number is complaint number 2024-045831. This case was administratively opened following a routine inspection conducted on August 5th, 2024. During the course of this routine inspection, the inspector observed the following. Funeral director and embalmer employed with the respondent establishment allowed their funeral directors and embalmers licenses to expire on June 30th, 2024, and did not reinstate their licenses until July 11th, 2024. During the unlicensed period, the employee signed off on 2 contracts. Respondent replied stating that they were unaware of the licensure lapse of their employee and that upon being notified, the employee immediately renewed their licenses. Based on the above, we would recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions for Mr. Bryant?
Motion to accept legal's recommendation.
Second.
It's a motion by Mr. Lee, a second by Mr. Wheeler. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carried.
Next complaint is complaint number 2024-045891. This case was administratively opened following a routine inspection conducted on August 6, 2024. During the course of this routine inspection, the inspector observed the following. The same individual from the previous complaint who allowed their funeral director's license and embalmer's licenses to expire on June 30th, 2024, did not reinstate them until July 11th, 2024, is also employed by respondent establishment. During the unlicensed period, the individual wrote 1 contract for this respondent establishment. Again, respondent replied stating that they are unaware of the licensure lapse and of their employee, and that upon being notified, they immediately renewed their licenses. Based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions?
Motion to approve.
Second.
Motion to approve by Mr. Haynes, a second by Mr. Wheeler. Any other discussion? All in favor, say aye. Any opposed? Motion carries.
Next complaints are complaint number 2024-045851, which represents the respondent's funeral director's license, and 2024-045901, which represents the respondent's embalmer's license. Respondent is the individual from the previous 2 complaints who allowed their licenses to expire June 30th, 2024, did not reinstate them until July 11th, 2024. During that unlicensed period, they signed off on 3 total contracts. Respondent replied stating that they inadvertently recorded their license expiration date incorrectly in their calendar. Respondent stated that once it was brought to their attention that their licenses had lapsed, they immediately renewed them. And based on the above, we'd recommend a $250 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions for Mr. Bryant?
Motion to accept council's recommendation.
Second.
Have a motion by Mr. Lee, a second by Mr. Nash. Any other discussion? All in favor, please say aye.
Aye.
Any opposed? Thank you. Motion carries.
Next complaint is complaint number 2024-047521. This case was administratively opened following a routine inspection conducted on August 22nd, 2024. During the course of this routine inspection, the inspector observed the following. The previous establishment manager had resigned on July 19th, 2024. As of the date of the inspection, the application for change of establishment manager had not been submitted to the board office, nor had the applicable fee been paid. During the inspection, the inspector met with the office manager, who confirmed that the previous manager was no longer employed at the funeral establishment. Respondent replied stating that the previous manager quit, but stated, quote, "I did not call this date in the allotted time for dismissing an employee," end quote. Additionally, an advertisement for respondent indicated specific prices for merchandise or services offered. However, the advertisement did not have an itemized listing showing the prices of each item offered. Based on the above, we'd recommend a $500 civil penalty authorized via consent order and a formal hearing if necessary.
Any questions?
Motion to accept.
Second.
Have a first by Mr. Nash, a second by Mr. Wheeler. I do have a question. Is the $500 civil penalty more for the advertisement or for the change of establishment manager, or a combination?
I would say a combination, essentially a $250 civil penalty for each violation, and when the consent order is written up, both violations will be in that document.
And could we remind the public again about the change of establishment manager? What is that time frame?
It is within 10 days
10
of that
days.
change.
10 days, okay. So there's a motion on the floor by Mr. Nash and a second by Mr. Wheeler. Any other discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-047601. This case was administratively opened following a routine inspection conducted on August 20th, 2024. During the course of this routine inspection, the inspector observed the following. The establishment license for respondent establishment expired on June 30th, 2024, and was not renewed until July 10th, 2024. During this unlicensed period, the establishment remained open for business, and one contract was written. Respondent replied, stating that there were issues renewing the license due to CORE. Respondent explained that the license had been linked through an old website they no longer had access to, and that during the unlicensed period they were attempting to renew the license. Respondent stated that once they were able to get into CORE, they successfully renewed their license. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and a formal hearing if necessary.
Any questions?
May I make a comment, Mr.
Sure.
President?
Sure, Mr.
The office calls each establishment prior to the expiration of their license each month, starting about 7, Ms. Bohannon oversees that, starting about 7 to 10 days before the end of the month if their license is not renewed. Sometimes we make multiple calls, and sometimes people will wait till the very end, and sometimes there are problems with the licensing system.
Thank you, Mr. Gribble.
You can start renewing your license within 45 days. I think the computer will open up, is it 45 days?
Almost 60. It's
Almost
been-
60, okay.
Typically, the renewal notices go out on the second day of the month. Like for October the 2nd, they will go out for for November.
Okay.
So
Yeah.
58 to 60 days ahead of time, you have that window. And I would encourage people to not wait till the last minute, and not wait if it's a holiday weekend or a weekend. Don't wait till then to renew it, because there can be problems. But if they have problems, if they'll call, we have people be glad to help them.
That was my next question, I guess, Mr. Gerber, was the state notifies them ahead of time. So the responsibility lies with them. If they have problems, you all are accessible to assist them with what they need to get into the core system and get their license done, correct? So the responsibility solely lies with that person or establishment and not getting their license renewed.
Now, we do not call individuals. We don't have the.
Yes, but you do
ability-
businesses.
But establishments, pre-need sellers and cemeteries, we do call them each
Okay.
month.
Okay.
I make a motion to approve.
Second.
Motion by Mr. Nash, a second by Mr. Naylor. Any other discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carried. Before we go any further, Mr. Bryant, thank you for reminding us after 9 of these cases that we need to be mindful of being consistent. Mr. Bryant, our next one.
Next complaint is complaint number 2024-044011. Complainant stated that on June 14th, 2024, they were terminated from their job at respondent establishment for time theft. Complainant alleges that after their termination, the establishment operated without a licensed funeral director. Complainant further stated that they were aware that the HR representative was conducting unlicensed activity by giving out price amounts for services without a licensed funeral director present. A brief note on this one, roughly 80% of the complaint was omitted from the summary, as complainant went into detail regarding why they disputed their termination for time theft and the details leading up to that termination. Respondent replied stating that they always have a licensed funeral director on site when families are present or when a funeral service is being conducted. Respondent stated that as of the date of their response, August 30th, 2024, a licensed individual was the manager at respondent establishment. Respondent denied, stating that at no time has an unlicensed associate given out pricing information and stated that all calls are given to a licensed funeral director. The vast majority of the complaint involves complainant's objection to what they consider to be a wrongful termination. That is a workplace dispute that is not to be determined by the board. Although complainant contends to know that an unlicensed individual conducted unlicensed activity since their termination, they provide no tangible evidence other than their claim. Furthermore, legal checked core and determined that a change of manager application and payment had been received as of June 19th, 2024, which is within the 10-day window as required by applicable laws and rules. Thus, based on the above, we'd recommend closure.
Any questions?
Motion to accept council recommendation.
Did you get that, Ms. Nash? I couldn't hear. Did you- Second.
Okay. Motion on the floor by Mr. Naylor, second by Mr. Nash. Any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaints are complaint number 2024-045621, which is against the funeral establishment license, and 2024-045661, which is against respondent's funeral director's license. Complainant alleged that respondent funeral director had engaged in misleading and deceptive behavior on behalf of respondent establishment regarding the terms of an insurance policy. Complainant stated that they have an uncle who they claimed passed away in November of 2023, whose life insurance policy was released to a family member that was not the beneficiary. Complainant did not attach any documentation at this time. Complainant also identified the decedent as having died at a different location than reported by respondent. Respondent replied stating that they had never met the complainant nor made arrangements with them. Respondent stated that the decedent complainant is referring to died on March 19th, 2024, and that he, the respondent, made arrangements with the decedent's brother on March 21st, 2024, and that services were paid in full via cashier's check. Respondent stated they have no knowledge of an insurance policy and that the decedent was picked up from a different facility the complainant contended. Respondent further stated that he contacted the decedent's brother regarding the allegation and that the brother stated complainant provided false information. Respondent attached the authorization for removal of body, embalming, and removal of medical devices. The document showed that the decedent had been picked up from the facility identified by respondent and that it was signed for on March 21st, 2024. Respondent also attached the death certificate, which identified the date of death as March 19th, 2024. Finally, respondent attached a copy of the cashier's check provided by the brother that paid for the services. Complainant provided a rebuttal stating that respondent was providing false information and that she had initially contacted respondent in January of 2024. As purported proof of this, complainant attached a Google review to the rebuttal to show they had an interaction prior to March of 2024. However, the Google review is not timestamped. The only indication of time is that at the time of the screenshot, respondent's reply on the review was dated, quote, 3 months ago, end quote. Complainant provided a second rebuttal, stating that respondent had told them in January that the decedent had been cremated and stated that decedent did have a life insurance policy. As purported proof of this policy, complainant attached a screenshot of a text message chain purporting to be from the decedent's nephew, the son of the decedent's sister, who, as complainant contends, admits to using the life insurance money. However, from legal's review, the screenshot only includes a number with no identifying information as to who the text conversation is with and does not admit to using the insurance fund. Complainant submitted a third rebuttal, again alleging that the information respondent submitted was fraudulent. As evidence of this, complainant stated that on the check respondent provided, it had the wife's nickname on the check rather than her legal name, and as complainant argues, a nickname would not be on the check. Complainant also points out a misspelling in the memo of the check as evidence that the check is fraudulent. The memo misspells the decedent's name, substituting a P where a B should have gone. Complainant also attached a communication with a private investigator hired in January of 2024 and purported this as proof that the decedent had passed in November of 2023, stating, quote, "Why would I hire a private investigator in January 24 if the decedent did not pass until March 19th, 2024, end quote. Finally, complainant submitted a fourth rebuttal stating that respondent and 14 other family members had all conspired to commit fraudulent activities regarding the death of the decedent and alleged that the insurance policy was stolen and forged by respondent. Complainant made allegations that they, presumably the family members, had opened bank accounts using false business names to transport money among themselves and alleged that they had been stealing from the decedent's bank account as far back as December 2022 when the decedent was initially found unresponsive. Complainant provided a screenshot of a text message from complainant's aunt saying to leave her out of whatever it was the family was doing. Complainant contends that this is proof the family was engaging in fraudulent activity. Based on the above, the overwhelming amount of this complaint appears to be family-related issues. Complainant's only complaint against respondent appears to be that they allegedly forged information related to the insurance policy. Complainant has provided no specific proof of this allegation, and respondent has provided proof to the contrary, showing a check and cashier's check from the decedent's brother used to pay for services. Complainant's general allegation that the decedent passed away in November of 2023 is refuted by the death certificate, which designates the death of the decedent as March 19, 2024. While legal cannot say with utmost certainty that complainant's family have not done the things alleged in the complaint and numerous rebuttals, that is for a civil or criminal court to determine, not this board. So based on the above, we'd recommend closure for both the funeral establishment and the funeral director.
Could you read that again, Mr. President?
Just take it from the top, or
Do you need a bottle of water or some oxygen?
Asking for if you wanted water.
Once again, thank you for always going above and beyond and detailing everything. It's just sad that we have to deal with certain things like this, but I make a motion to accept council's recommendation for closure.
Second.
I have a motion by Mr. Lee and a second by a couple of people, but I'll say Mr. Naylor since he's sitting close to me here and I heard him first. Any other questions or discussions on this case?
I have a question.
Okay.
This is still a little new board member here, so I want to make sure I understand this. Even though that complaint really has nothing, there's nothing we can really do about that, and we know that from what you read, we still have to hear it, correct?
Correct, yes. Once a complaint has been filed, there essentially is, I mean, we've even seen before where complainants contact us and say, hey, there was a misunderstanding, I want to withdraw my complaint. And even then, just as a matter of course, the board has to hear it. And I, of course, would let you all know if that had occurred. But yes, once it's been filed, it's got to go through.
That's what I thought. I just wanted to make sure I understood that.
It's a good question, Mr. Nash. So there's a motion on the floor by Mr. Lee, a second by Mr. Naylor. Any other questions or discussions? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-037861. On July 5th, 2024, an employee of the Tennessee Department of Health contacted the board office requesting assistance with delinquent death certificates. The employee provided a screenshot of respondent's queue denoting the various death certificates that had been assigned to respondent. Specifically, complainant stated that at the time of the complaint, 9 death certificates had been certified and required only for respondent to release the death certificate. Respondent stated that after the complaint was filed, they logged onto Verizon with the complainant and discovered that there was a glitch in the system that prevented certain actions from showing the appropriate tab. For example, assigning to directors did not show up in the proper tab. Respondent further stated that they were provided the resource from complainant where they can file complaints against doctors for delay in certifying death certificates, and the respondent indicated they had filed complaints against 6 doctors on August 13th, 2024. Respondent stated that their staff are checking Verizon daily and notating in the system each time they receive a call from a doctor's office, and respondent stated that they will notate when the cases have been reassigned or doctors failed to timely sign. Complainant was forwarded a copy of their response and specifically was asked about the determination of the glitch. Complainant confirmed that there was indeed a glitch, but that the glitch involved being unable to see the date the funeral home assigned the case to the physician, and clarified that the glitch did not affect the assignment to the physician. Complainant stated they have a fixed date assigned for the problem and hope that the glitch is resolved soon. As of the complainant's update, which was September 24th, 2024, respondent had reduced the number of death certificates that needed certification, which needed to be released, from 9 to 3. Based on the above, from legal's understanding, the glitch in Verizon does not affect whether respondent releases the death certificate once they had been assigned, and that the glitch only affects some cases in determining what date the death certificate was assigned to the physician. That is, the glitch should not affect respondent's failures to release the death certificates. Based on the above, would recommend a $1,500 civil penalty to authorize via consent order and a formal hearing if necessary.
Are there any questions?
Just a statement from me. I noticed there's also a history of the same problems. And that's the simplest thing to do is release them. It's been signed, it's been certified. You got to wire it in. That's my 2 cents worth, but make a motion to accept council's recommendation for $1,500 civil penalty.
Second.
There's a motion on the floor by Mr. Lee, a second by Mr. Wheeler. Any other questions or discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Next complaint is complaint number 2024-046021. Complainant alleged that respondent had embalmed the decedent, their son, without permission. Specifically, complainant stated that on August 10th, 2024, she gave respondent permission to pick the decedent up from the hospital upon his passing. Complainant at first states that the only thing they spoke about during this call was whether the decedent had insurance, where complainants contend she told respondent the decedent did have insurance. But in the next sentence of the complaint states that they spoke about funeral arrangements and other details as respondent had various questions, which ultimately led to the complainant stating that she didn't want to speak with him about that at this time. Complainant set an arrangement conference with respondent for August 12, 2024 at 11 a.m. Complainant stated that respondent again inquired about the insurance and instructed her to bring any paperwork regarding that insurance. However, complainant denied that the decedent had life insurance and now confirmed to respondent that everything would be self-pay. Complainant stated she was instructed only to bring the decedent's Social Security card. However, complainant stated that on August 12, 2024, 30 minutes after the scheduled appointment of the respondent, she was walking into a different funeral home to discuss and sign paperwork for the decedent's arrangements. Complainant stated she received a call from respondent inquiring why she was not at her scheduled appointment, to which she responded that she, quote, would call him back, end quote, but admits in the complaint that she never did. Complainant stated that when she spoke to respondent again about transferring the decedent to a different funeral home, he disclosed that the decedent had already been embalmed and that complainant would incur charges for embalming and transfer. Complainant stated that she was still under the impression that the decedent was at the hospital morgue. Complainant stated she asked respondent who had authorized the embalming of the decedent and claimed that respondent indicated she had given verbal authorization during their conversation at the hospital. Respondent replied stating on August 10, 2024, he received a call at 4:08 p.m. from the father of the decedent, husband to the complainant, indicating that his son had passed away. Respondent stated that the husband indicated he had provided services to his father and another family member and wished to use his services again. The father provided the necessary information to respondent, and when respondent inquired whether it would be insurance or self-pay, the father indicated he was not sure and passed the phone to complainant. Respondent stated he asked a few general questions, such as what kind of service she wanted, burial, cremation, and insurance or self-pay. Complainant indicated she wanted a funeral with a viewing, burial, and insurance. Respondent stated at this time he indicated he would need her to authorize to embalm the decedent, and that at 4:14 p.m., complainant granted verbal authorization to embalm the decedent. Respondent indicated he told complainant he could not make the removal until he received a call from the hospital, to which complainant understood. Respondent stated they were called early in the morning on August 11th, 2024 by the hospital for pickup. Due to the authorization given, the decedent was picked up immediately following the call and promptly embalmed. Following this, respondent called complainant, informed her that the decedent had been picked up and prepared, and the two scheduled an arrangement conference for 11 a.m. During this conversation, respondent stated he explained the process to complainant and informed her she would need to bring the insurance paperwork. At this time, complainant indicated they did not have insurance and would be paying out of pocket, and respondent indicated she would just need to bring the decedent's Social Security card. At 11:30 a.m., when complainant had not arrived, respondent called complainant inquiring when complainant would arrive. Respondent claims complainant indicated she did not know and would call him back. Several minutes later, respondent received a call from a funeral director at a different funeral home asking for the accrued charges. Respondent gave the funeral director the charges, and the funeral director indicated they were not aware that respondent had already received the decedent. Respondent stated that complainant was aware of this as they had spoken yesterday. Soon after this conversation, respondent stated he received a call from the father of the decedent, who inquired about what was going on regarding the decedent. Respondent advised that the complainant had requested a transfer, and according to respondent, this was being done without the father's knowledge. Respondent stated that soon after the scheduled appointment time, while away from the funeral home, complainant arrived at the funeral establishment wishing to meet with respondent. Respondent stated complainant used profanity upon his arrival, acted with aggressive behavior to the point that respondent threatened to call the police and asked that she leave the premises. Respondent stated that complainant was ultimately banned from the property, and thus the transfer documentation was signed by another family member. Respondent stated as of August 14th, 2024 at 9:15 a.m., the decedent was transferred to a separate funeral home. Respondent also attached the transfer documentation and notes that had been written indicating the verbal authorization to embalm and cremate had been given during the August 10th, 2024 at 4:14 p.m. as indicated by respondent. Based on the above, way to recommend closure. And I know there's a lot there, so certainly understand if there are questions.
Just to clarify, the very last paragraph, you said that verbal authorization to cremate had been given. Should that be embalmed?
It should.
Okay,
That's
okay.
my fault.
Just- If no
I make
question,
a-
I'm sorry.
Sorry, I was just saying, make a
Go ahead.
motion to accept council's recommendation.
I'll second it.
Have a first by Mr. Nash, a second by Mr. Lee. Any other questions regarding this? All in favor, say aye. Aye. Any opposed? Motion carries.
Next complaint is complaint number 2024-04831. Complainant, mother of the decedent, alleged unprofessional conduct on behalf of respondent. Specifically, complainant alleged that respondent establishment allowed her son's body to stay at the city morgue for 11 days. Specifically alleging that they were contacted on July 19th, 2024, and did not pick up the decedent until July 30th, 2024. Complainant stated they contacted respondent on July 17th, 2024, and arranged for cremation and celebration of life for the decedent. Complainant stated that a funeral director at respondent establishment advised that she contact the city morgue to let them know that respondent would be the one to pick up the decedent and to call respondent to advise when the body was ready for pickup. Complainant stated that on July 23rd, 2024, they called the funeral director and asked if the body had been picked up yet. Complainant stated they were told no, and that no one from the morgue had called a respondent informing them they could pick up the body. On July 24th, 2024, complainant claims they went to respondent establishment and asked if the body had been picked up. Complainant claims they were told yes, and then asked when the decedent would be cremated. Complainant alleged they were told it would be Tuesday, 6 days later at the very latest. Complainant stated they called respondent again on July 30th, 2024, to ask if the decedent had been picked up and cremated. Complainant claimed the individual acted as if they were unfamiliar with complainant's inquiry and stated they would call her back. Complainant stated they called the morgue and was told that the decedent's body was still there, and claimed to have been told that the morgue notified respondent on July 19th that the body was ready and available for pickup. Complainant stated they also spoke to a doctor at the morgue who too confirmed respondent had been contacted on July 19th to pick up the body. Complainant stated the doctor offered to call respondent again and call complainant back when the body had been picked up. Complainant stated the doctor called back at 11:13 and confirmed the body had been picked up. Complainant further claimed that Complainant further claimed that they called respondent on July 30th, 2024, and said that they, quote, chose to leave the body at the city morgue because they didn't have room in the freezer at the funeral home, and the city morgue could better accommodate her son's body, end quote. Complainant stated that they refused to answer any other questions from complainant. Respondent replied stating that the 11-day delay in picking up the decedent from the morgue was because the body had already decomposed, and that based upon that decomposition, they did not have sufficient room in the cooler to maintain the body until the proper permits were issued. Respondent stated that when they received the necessary permits from the Tennessee Department of Health on July 30th, 2024, respondent establishment picked up the body the same day and delivered it to the crematory for the cremation. On October 1, 2024, legal requested to receive the permits that respondent had received from the Tennessee Department of Health and received them the following day. From legal's review of the cremation permit received from the Tennessee Department of Health, it appears that respondent applied for the permit on July 30th, 2024, and received approval the same day. Legal also contacted the individual complainant spoke with at the morgue. However, the individual had to clear the conversation with their legal counsel, and at this time, legal has not heard back. Based on the above, we'd recommend a $1,000 civil penalty, authorized via consent order, and a formal hearing if necessary.
So they actually met, thank you. So they actually met with the funeral director, made the arrangements on the 17th, and they didn't even apply for the permits to July 30th.
That's my understanding.
And the penalties for unprofessional conduct, is that correct?
Correct.
I make a motion to approve council's recommendation.
Second.
Have a motion by Mr. Wheeler and a second by Mr. Nash. Any other questions or comments? All in favor, please say aye. Aye. Any opposed? Motion carries.
And the last complaint is a represent from, I believe, the August meeting, which is complaint number 2024-023611. As a reminder, it was presented as complainant alleged that respondent had failed to send the cremains and remaining insurance policy funds to them, the granddaughter of the decedent. However, complainant did not provide any next of kin information in whether they were entitled to receive the cremains or the remaining funds. Respondent did not reply to the complaint. Legal called the complainant and inquired about next of kin determination. Complainant stated that she did have a father involved in the arrangements, but that the insurance policy listed them, the complainant, as the beneficiary. Complainant stated that although their father made determination as to the arrangements, complainant was listed as the policy beneficiary. Complainant explained that they had asked the funeral director if it was possible to send some cremains to her as well, since her and her father lived in different states. Complainant stated that the funeral director confirmed this would not be an issue. Complainant updated legal that they have still not received any contact from respondent regarding these matters. At the time, we assessed it as recommended an assessment of $2,000 civil penalty related to unprofessional conduct and failure to respond to the complaint. The board asked that we send it for further investigation to determine the status of the insurance policy, whether the beneficiary of the policy was changed, and where the cremains were at this time. So this case was sent for further investigation. The investigator met first with the owner of respondent establishment. As a reminder to this case, complainant is the granddaughter of the decedent. The owner stated that they had provided funeral services for the grandmother's husband approximately 10 years ago, and that he had maintained a friendship with the grandmother following her husband's passing. The owner stated that the grandmother often called and confided in him, and that she requested that at the time of her death, respondent establishment handle the arrangements in a similar manner as they had done with her husband. The owner stated that when the grandmother's health began to fail, one of the grandmother's sons was made POA and that she was placed in a low-cost nursing home. The owner stated that the grandmother informed him that the son had taken all of her money. Further, the owner stated that during his visits to the nursing home to visit the grandmother, she stated that she had 2 insurance policies, and because of her friendship with the owner and due to the way the sons had treated her, the grandmother wished for the owner to have the proceeds of the 2 insurance policies. The grandmother eventually passed away on July 27, 2023, with the son as the POA making funeral arrangements, with a service conducted on August 5, 2023. The owner stated that he had both sons sign the cremation authorization form. Likewise, the POA and complainant signed the assignment form for the respondent establishment to be assigned as the recipient of one of the insurance policies in the amount of $4,280 to pay for the funeral and cremation services. The second was an assignment for an insurance policy in the amount of $3,040 signed by the complainant. The owner stated that he had spoken to complainant on multiple occasions, explaining that the decedent, complainant's grandmother, wanted him to have the proceeds of the insurance policy. However, the owner was unable to provide any written correspondence from the grandmother, formal, such as a change of beneficiary form, or informal, such as a typed or written letter from the grandmother expressing their intent to change the beneficiary. The owner, who is not a licensed funeral director, stated he was not aware that the change could not be verbal only. Finally, the only documentation that complainant provided regarding the insurance policy was a change of beneficiary form from 2018, changing the beneficiary from the grandmother's 2 sons to the complainant. Regarding the cremains, the owner showed the investigator the cremated ashes and explained that the POA is the next of kin, and stated that he was not authorized to release the cremains to anyone else, including complainant. The owner explained that the cremains have not been picked up by the POA, nor had he requested them to be shipped or given to anyone. The owner said they have reached out to the POA on more than one occasion regarding the cremains, but has not heard back. Regarding failure to respond to the complaint, the owner stated that he received a closure letter for the duplicate complaint the board authorized closure for in August and believed the matter had been resolved. So based on the above, even though the owner's belief that he had rightfully and legally been named the beneficiary of the policy, respondent is unable to provide any written documentation to support this. In a phone conversation with legal, the owner confirmed that written documentation did not exist, as the conversation with the grandmother had been verbal only and not memorialized in writing. Regarding the cremains, the owner has kept and reserved the cremains to be given to the POA once they pick them up or give permission to ship them to the POA. The owner indicated that there is significant tension amongst the family, and their attempts to get in touch with the POA to provide the cremains in whatever way they approve has been unsuccessful. Regarding failing to respond to the complaint, a respondent is required to respond to a complaint within 14 days of receiving the complaint. Technically speaking, a response submitted on the 15th day is a violation of applicable rules because it is late, as it is outside the 14-day window. Respondent's obligation was to respond to the complaint on the front end, not the back end. Ironically, while the owner may have had some confusion due to the duplicate complaint, respondent had 2 opportunities to respond to an identical complaint and failed to do so on both. While the closure letter could have led the respondent to believe the matter had been completely resolved, that does not absolve respondent's obligation to reply that occurs at the beginning of the complaint's disposition, not the end. So one thing before I get to the recommendation that I will mention, I know typically there is a temptation to want to try and fix complaints if there are things hanging out there. And I think probably 9 times out of 10, we're unfortunately not in a position to be able to do that. I do think this is one of those very rare occasions where a consent order and civil penalty assessment could help one matter that is still outstanding. So based on that, the recommendation would be an $8,500 civil penalty plus the cost of investigation to be reduced to $1,500 civil penalty plus the cost of investigation, provided respondent transfers that $3,040 received as a result of the insurance funds to complainant. That would be authorized via consent order in a formal hearing if necessary.
Just a question, and I may have missed, I call myself looking for it. The insurance is not going to pay anybody except the beneficiary, correct?
So if I'm understanding your question correctly, that's correct. Based on what I understand from this, is that there were 2 insurance policies. One was assigned to respondent establishment. I think we're square there. Everything looks fine. The other was essentially, I'm not sure, I think it was maybe assigned in case, I'm not sure why it was assigned. That $3,040 is what's hanging out, that we have a lot of gaps in our documentation, but what we do have is an 8-year-old document, 8 or 6-year-old document from complainant, switching the beneficiaries from the decedent's 2 sons to her. And then we have a story of verbal permission that, no, I want you to be the recipient of those insurance policies. So since we don't have any formal documentation other than that last document, even though it's older, making the beneficiary the complainant, legally speaking, that $3,040 insurance policy should be hers.
And I guess what I'm saying is, even to do an assignment, the beneficiary would have to do the assignment to the owner of the funeral home, correct?
It says that she signed it. She signed it.
Okay.
She signed the assignment, but that, my biggest issue is that the respondent had the assignment, not my biggest issue, but they had 2 assignments, one to pay for everything, and the second one, which in my opinion was deceitful because they had a valid assignment already for the other amount. So, as with Mr. Lee, law enforcement background, that gets me a little fired up because it's theft, in a roundabout way. And
would any of this fall, I guess, in the civil court? That, I guess that's kind of, is it our determination to make him pay that back? Or would she have a legal standing to file a civil lawsuit against him?
No, she can certainly file a civil suit on that front. It's, if the board says that needs to be in their court, then that's totally fine. We do not have to structure the civil penalty in such a way that it incentivizes the respondent to refund it. If that gives the board apprehension, that's certainly no problem at all. I guess what is tricky is I'm not certain of the intent. One thing I will say is that the investigator spoke to the owner. I spoke to the owner over the phone with the investigator. And the investigator's read on the situation was that it was an honest belief that the assignment could be verbal. And you're welcome to judge that however you like. I won't say that it wasn't a deceitful attempt, but I could see how it was an earnest belief. Whether that changes anything at all or not is totally up to you all. But so again, to answer your question, Mr. Lee, if at the end of the day, the respondent just says, no, that's mine, I don't want to give it to you, the complainant can certainly file suit for that. And if structuring the civil penalty in a way that incentivizes the respondent to return the funds, gives the board pause, it's totally fine. We do not have to do it that way.
Okay.
And I sort of agree with Mr. Nash because I feel there was some deceit. And when you're with a family, and all of us have been with families, and you hand them paperwork and you explain to them, you need to sign this, here's why you need to sign. You know, we all have families that have more than one insurance policies when they pass away. And one policy might cover the funeral, but us as an establishment, we go ahead and file the other insurance for the family, and it's to be sent to the beneficiary. So I do go back to what Mr. Nash, there was an intent of deceit by this funeral director that put the money in his pocket when he should have never have had that amount. He could have filed for the benefits to go to the beneficiary, but it should have never been assigned to him, considering that first insurance policy covered all charges at the funeral establishment. So I have a lot of problems with that because, to me, you know, one of our biggest things is protection of the consumer. And we're to be honest with those people that choose us, that entrust us, and it is our responsibility to be honest with that consumer and give them what they're paying for and not charge them for any more than what they've paid for or what they've chosen.
Is the owner of this establishment an unlicensed individual, to my understanding?
That's correct,
And
yes.
so he or she, they have been the respondent in this case.
In a roundabout way. I mean, the owner is responding on behalf of the respondent, and the respondent is the funeral establishment.
So it also sounds to me like the owner, this unlicensed owner, is making funeral arrangements without a license to me.
I will say from reading it, I don't know that that's the case necessarily. I think specifically what our investigator was focused on was just essentially the board's directive
Yeah.
of, so I can't say that for certain.
My last question, I promise. So so I understand this, so $8,500 penalty plus investigation cost. But if this establishment pays the $3,040 to the complainant, we reduce it to $1,500 plus the investigation cost.
Correct.
I would make a motion that the reduced amount be $2,500 plus the investigation costs so just essentially changing the $1,500 to $2,500. Do you mean to read it all the way out?
Yes.
I make a motion to change the recommendation to an $8,500 civil penalty plus cost of investigation to be reduced to $2,500 plus cost of investigations provided respondent transfers the $3,040 received as a result of insurance funds to complainant, and authorize a consent order and formal hearing if necessary.
There's a motion on the floor.
I'll second. And simple contract or something on paper would have saved them a lot of trouble.
And I do have one more question,
Sure.
Mr. Bryant. What about the cremains? That seems to be a point of contention, and, I mean, if he had someone make arrangements, he's got an address, he can put them in the mail and mail them directly to the person who is in charge.
He did mention that it's their policy that they don't mail cremains unless they have specific approval to do so. He says that he's reached out to the POA of, I can mail them to you, you can come pick them up, I can send them to someone else, like, please tell me what to do. And that just kind of gets static, just no response.
Yep. Any other discussion? There's a motion on the floor by Mr. Nash with the change of the penalty from $1,500 to $2,500, and a second by Mr. Lee. Any other discussion regarding this case? All in favor, say aye. Aye. Any opposed? Motion carries. Mr. Bryant, as always, thank you so much for all you do. At this time, I'm going to ask Mr. Gribble if you would give us your executive director's report.
Good morning, board members. The first is the licensee reports, the report of license administratively approved by the executive director pursuant to board authority for the period of September 7, 2024 through October 4, 2023. I think it's probably the lightest number of licensees that have ever been approved. Of course, it's not entirely for 1 month, but almost. One establishment change of ownership, 2 individuals, 1 funeral director and embalmer, and then 1 just a funeral director. Not much activity on that side. Closed establishment reports. We have no closed establishments to report to you. Disciplinary action reports. A report of consent orders that have been administratively accepted and approved by the executive director pursuant to board authority, and as reported on the August 2024 regulatory board disciplinary action report. And that report's a little bit longer than usual this month. But you have the name of the respondents there listed, their location, their violation, and the civil penalty. Then the complaint report with the, and I will say what's enlarged that is the number of people that haven't renewed their licenses on time and caused complaints to be opened. But this month, the number of complaints is higher than normal. We have 37 open complaints against a funeral director and/or embalmer, and 35 against an establishment, for a total of 72 complaints as of October the 2nd, 2024. And I want to take just a second to mention to you something about financial information. Let you know as soon as we get the final year end, we're talking about, when I say year end, I'm talking about for the fiscal year that ended June the 30th. States on a July 1 through June 30 fiscal year. So when we get the final numbers, we'll give you a more detailed report. I will say the sky is not falling, but I was very disappointed that we ended the fiscal year with everybody trying to help as much as they could, doing all the things we could to save money, to make sure that each expense was what it needed to be, and there was no wasted expenses. The funeral board ended the fiscal year with about, it looks like, a deficit of close to $26,000, which means that that's the second year in a row that we've had a deficit. It's the first time that's occurred in many, many years. So come January, the board will have to go before the Government Operations Committee for a self-sufficiency hearing. Now, the board has about $1 million in a reserve account, but it's not as simple as taking $26,000 out of that account and saying, okay, the books are even. Anytime that there's a board that has a deficit for 2 consecutive years, then we're required to go to government appear before the Government Ops Committee. And the funeral board, because historically most licensees renew their license on June the 30th of the even numbered years, typically, 1 year we've always had a deficit, but the next year it's been usually the surplus used to be 200,000 and got to 75,000. And then this year we had, for some reason, a huge amount of people as you can see from these complaints, that didn't renew by June the 30th. Well, if the money comes in July the 1st, it goes in the next fiscal year. It doesn't go back to that. So like I say, the board, President Stevens, the board are investigator or field representatives that do traveling. We tried to make sure that every penny was spent wisely. And we get, don't want to bore you with the details, but just so you know, we get a report each month showing where we are financially, what the expenses are. I review that, and if I have questions, and I have people I talk to and send emails, and they answer those questions. So we get expense report for July. Then we get what's called a 991, which is the first report after that. We get a 992, which is the second report after that. And then I just got the 993 just last week. And that's where I can't remember how much over 26,000 it is. It's somewhere between $26,000 and $27,000 is what the deficit is. And that looks like that's a final number. They will give us a 3-year comparative, and hopefully I'll have that for you for the next board meeting. And it'll also give you a financial recap and show you the details of where the expenses were. Again, I was so disappointed because I thought we tracked it out. There's a person in the assistant commissioner's office that works with us on financial matters, and we thought we were there, but we weren't. So it disappointing, but I'll have, again, the sky's not falling. The board's physically sound. It's just that for that particular time frame. And then one other thing I wanted to say too, we had a lot of people that just didn't elected not to renew their license this year, especially older individuals who are either, no longer associated at all with the funeral home, or who may be associated still in ownership or something, but just don't practice. They decide not to renew. So when you look at $230 or $235 for the renewal fees, it doesn't take a whole lot of those to come up to $20-something thousand. I mean, when they decide not to renew. But I'll give you more information about that next month. But I'll be glad to answer any questions about that or anything else I mentioned if you have a question.
Thank you, Mr. Gribble. You've explained a domino effect where the licensings, and we, as a board, want to again remind individuals and establishment facilities to renew those licenses and to be able to get that money into the budget so that Mr. Gribble is not facing that again. So, with that said, I'll entertain a motion to accept Mr. Gribble's Executive Director's report.
So moved.
Okay?
Second.
Have a motion by Mr. Wheeler and a second by Mr. Nash. Any other questions for Mr. Gribble? All in favor say aye. Aye. Any opposed? Motion carries. This time, I think we have a new establishment application. And so that I don't botch anything up, could you introduce yourselves and the name of your organization?
I'm Harold Ford. I'm the CEO of Serenity Columbarium and Memorial Gardens and Serenity Funeral Home and several other LLC licensed funeral homes in Memphis.
Thank you.
I'm Glorinette Lopez,
Okay.
and I will be the establishment manager.
So tell us about and could you pronounce the name of your organization?
Funeraria Garcia Rodriguez.
Very grateful you did that for us. Thank you.
You're welcome.
And could give us a little background about yourself and your hopes for opening a new establishment.
It's you, but you, she said.
Okay. I've been a licensed funeral director and embalmer in the state of Tennessee since 2007. I worked in Nashville for almost 10 years, and I've been in Memphis for 11 years now.
Where did you work in Nashville?
Woodbine Funeral Home,
Oh, I thought you looked familiar, okay. For 10 years there,
almost.
yeah.
And so I've been at Serenity for 11 years in Memphis, and part of the Serenity campus vision that Mr. Ford had when he hired me 11 years ago was to open a fully Hispanic funeral home.
Okay.
And so we are at that point finally.
The board is looking at some of your documents. I know they have previously before the meeting, but do any of you have any questions?
I have no questions. I've looked, everything appears to be in order. Now,
Mr. Gribble?
Board members, Mr. Ford and I talked just before the board meeting. It appears that there may need to be an amended application to change the name of the owner because the proposed name of the establishment is an LLC, and that LLC will own the establishment. There's no need for them to change their name. Their name is fine. But listed on the application is the name of one of, as Mr. Ford explained to me, everything rolls up to the top to the LLC that's listed on the application, but the actual owner of this establishment will be and I apologize, I cannot pronounce it. And appreciate Ms. Glorinet doing that. And then there was a little bit disconnect of the members of the LLC. The application shows 3 members of the LLC, and the Secretary of State's website for this LLC that owns the application shows 1 member. So it's nothing that would prevent the board if they decide to approve it. Nothing that would prevent that. If the board decided to approve it, then we could work this out in the next day or so and issue a license. If it's nothing major, it's just minor things that we need to look at.
And it's probably what I sent over to the law firm. Right now, we have Serenity Funeral Home, which is an LLC, Serenity Funeral Home and Cremation Society, which is LLC, and the parent company is Serenity Columbarian and Memorial Gardens. And we opened this entity, and I guess what happened, we put Serenity down as the owner, but we will amend that immediately and send that into the state. And I mentioned to Mr. Gribble in the hallway that we would get it out this afternoon. I am the sole owner of all of them, and we just put the corporate name on it that owned it, which it will be when we roll up with taxes and all, and we file our, income taxes.
Mr. Gribble, I had seen the amended application in here, so there needs to be another amended?
Yes,
Okay.
we'll get that out on the way back.
Madam President, I make a motion that we approve the licenses of, you want to help me out? With
Funeraria Garcia Rodriguez.
Fernandez Garcia Rodriguez.
Don't even try. Okay, so there is a motion on the floor by Mr. Naylor.
Second.
A
With the
second,
amendment that they filed, the amendment with the state with Mr. Gribble.
so the motion on the floor, if you agree, is that the motion would be carried with the amendments that need to be made by the state and by the owners and but through the office of the state board. Is that correct? Okay, Mr. Haynes as well?
Yes.
Any other discussion? I'd like to say congratulations to both of you. Let's call for the vote. All in favor, say aye.
Aye.
Any opposed? Congratulations.
Thank you,
Thank
board
you.
members.
Thank you.
Thank you.
Okay. Is there any new business that needs to be brought before the board? Are there any, Ms. Bohannon, were there any signatures next to the person's name for public comment?
No, ma'am.
Is there anyone in the room that has a public comment that has not had an opportunity to sign? Mr. Gribble?
Just asking what you want to do. Do you want to ask the board members that are interested in declaring for an office for next year to do that at this meeting?
Oh, thank you for reminding me.
Since it could be either on the agenda for November or December, one of those two times.
We had a preliminary discussion about that at our last meeting. Have you had anyone, or Ms. Bohannon, have you had anyone reach out to you regarding that?
I have, but I think that that would be best for the members themselves to.
Sure.
If it is okay with you, Ms. Stevens, I think
Sure.
that would probably be best.
Sure. So at this time, I would like to ask if there is anyone that is interested in a leadership position, and is that for vice president?
Vice President?
For vice president.
I was also interested, Madam President.
Okay. Okay.
For Vice President.
Okay. Mr. Naylor. And then there's another position, right?
Well, of course, you elect the president. I assume that you probably assume that
Okay.
that will be the current vice president.
I will officially ask for the nomination for
For
president
president?
of the board next year, my final year, and I really appreciate being on it.
Okay.
And then there's a
There is
continuing
a-
education liaison that the board appoints. It's not an elected position, but it's an appointed position.
I would be interested in the continuing education
Okay.
liaison.
Mr. Haynes.
Better
Okay.
think about it, Mr. Haynes.
So I have been told.
So these three positions have been addressed, and we will vote on those next meeting. And I will repeat that. The president, Christopher Lee, vice president, we will determine either Mr. Wheeler or Mr. Naylor. And then the continued education. Anyone else on that?
I don't think anybody else is that crazy.
Okay. Mr. Haynes?
I don't fall under it, so why would I want to do it?
Okay, so this will be continued at our next meeting in November, which is scheduled for November 12th. Anybody else have any public comments? I have one. There's a young man in the audience, and I just wanted to bring attention to his name. His name is Eli Ridgway. He is a student at John Gupton. And I wanted to remind Eli that your grandfather served on this board, and your father has served on the Tennessee Funeral Directors Association board. And as being third generation, we're very proud of you and hope you continue the legacy of your family. Any other business that needs to be brought before this board? If not, I will entertain a motion for adjournment.
So moved.
Do I hear it from everybody? So moved, second, and this meeting is adjourned. Thank you so much.